no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial in these witnesses' testimony. To the extent that they did occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these alleged and very reprehensible things that they were describing. In one notable instance, Jennifer McCabe recounted being harassed by a blogger. She didn't name the blogger, but she said, quote, "The defense is very familiar with this person," end quote. That was her trial testimony, and she looked right at the jurors when she said it. The very obvious overture was, you know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it. In some way, shape, form, or fashion. She outright suggested to the jury that Ms. Reed and the defense were responsible for the acts that she went on to describe in great detail, in which we agreed, if they occurred, are vile, reprehensible, unacceptable. There are clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others, consider an unjust prosecution of an innocent person for a crime that she did not commit. There is an enormous amount of emotion injected throughout the community, this community and beyond, and we don't control that. And if people have suffered as a result of that, Ms. Reed very specifically should not be the one to have to bear that burden, and she did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord. They certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down on the witness stand, which also happened, it serves to visit an extreme and an extraordinary prejudice against Ms. Reed, very, very specifically and very targeted like a laser on her. And it's for conduct that's completely out of her control and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable for witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? Probable cause standard,
that.
Right? Okay.
But notwithstanding that standard, the question was she in any way liable for that harassment and intimidation? And that standard is extremely low. We all know the ham sandwich anecdote. And even the grand jury said, no, there is absolutely nothing to see here. There is no evidence that she was responsible for intimidation or harassment such that they determined that there was a no bill. And what is bothersome is that the Commonwealth was aware of that and didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery when we finally found out that a no bill was issued indicating that Ms. Reed.
When was that no bill issued?
You said when or where?
When?
I want to say March 23rd, March 27th is what I'm being told. It was late March, before the first trial. And they knew this, and they didn't provide what I believed, and I think what the court would have ruled would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community or these bloggers.
So my memory is I kept it out, and then I have a very clear memory of you opening the door with Jennifer McCabe, and it came in through there.
So the court did make that ruling that ultimately, if the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling. I didn't think that we had opened the door. It was whatever that door was. It was on some very, very significant lubricant. It was going to be opened very easily.
Read the transcript.
I have several times. In any event, I believe that the court should make the exact same order this time and have a more defined, we should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed and the information came in. But it's so prejudicial. It was so extremely prejudicial as to Miss Reed that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, we can reasonably sidestep that as best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance is that we get a clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously, that would open the door. That's not what would happen. That's not what happened last time. What happened last time was Jennifer McCabe basically decided that she wanted to talk about that issue and sort of walked through it, at least in my view, having reviewed the transcript. In any event, I think the court understands what our concern is with regard to this subject matter. We don't want a free-for-all of people, one person after another walking into court and basically lambasting the defense for all intents and purposes about things that are completely out of our control. Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to, Ms. Reed very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed, that she's been the one engaging in this, which is, or the defense has, which is just not true. So we would ask for a clarifying order on that issue very specifically.
Mr. Brennan.
I can appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me, It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Ms. Reed talked about speaking frequently to Mr. Carney, sharing anything public with him. And you would have to choose to be oblivious to think that that information that is shared was then not generated to intimidate and harass witnesses for 2 years. In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense in the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept, but fraudulent, I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it. And to suggest they can stand here and bash witnesses in the text of their argument, unsolicited attacks, because it pleases them and fits their narrative, is something I can't just sit by and listen to. The Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at the family events. That didn't happen. And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations. That opens the door. And it will open the door again, I suspect. And we'll be prepared. I think the issue is really a trial issue and an attorney having control of their questions so they don't open the door. That really is the issue.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Okay.
Your Honor, if I may very briefly.
Sure, just give me 1 second. I want to take one note, okay?
Of course.
All right, go ahead, Mr. Jackson.
I just wonder if where this ire and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements. Was he listening? I didn't bash a witness. I didn't attack a witness. I didn't make any fraudulent statements. The Commonwealth made their best effort to tether Ms. Reed to Aiden Kearney. And they did it through a grand jury. And those members of the grand jury said, no, it's not true. It didn't happen. That's what they said at the lowest burden known in criminal justice. So Mr. Brennan can stand up all he wants and say, I saw a TV show and I saw this and I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. Sure, there may have been communication. That's very different from directing witness intimidation, directing witness harassment for the purposes of undermining a prosecution. That's what they've accused her of, and they failed. And then they kept that from us when they failed and allowed this sort of fabrication of the witness. And I'm not saying that the intimidation that was described on the witness stand was fabricated. That's not at all what I'm saying. Maybe it was true. Maybe it all happened. What was fabricated is that it was connected to Ms. Reed or connected to us. So nobody's up here, Your Honor, and I take issue with Mr. Brennan's tone and tenor. We can all be professional. We can all advocate very zealously and robustly. But let's keep it professional. I didn't stand up here and attack a witness, or what did he say, bash witnesses, use this as an opportunity to bash people. But we could calm the drama down just a little bit and probably get a little further. All we're asking is that it not come in, and I will stipulate and agree with Mr. Brennan that this not come in the Commonwealth's case in chief. And we will be very mindful of what would conceivably open a door to this kind of testimony. And I'll probably seek the court's guidance before I ask a specific question that I think comes anywhere close to that. we'll ask for the court's guidance by coming to sidebar. And I think that could resolve the issue.
Okay. Thank you. I'm going to look at this a little more closely. All right, the next one is paper 571, and the Commonwealth's corresponding is your number 12, our paper 586. So the defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. So who's arguing this for the defense? Because I'm going to ask you whether you want to argue your opposition to it or have the Commonwealth make their argument for admission of it. Who's arguing it for the defense?
Your Honor, I am. And to
Okay.
answer your question, the defense preference would be for the Commonwealth to go first, and
All
we
right.
would respond, including with regard to my motion.
Okay, so Mr. Brennan, our paper 386, your number 12.
Your Honor, our paper number 12 seeks to admit the results of the defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion and retrograde extrapolation. This being a OUI manslaughter and murder case, the statutes that the defense cites don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol. We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We've cited Chapter 233, Section 79 as a business record. I know the defense takes issue with that. However, these records are routinely admissible. Commonwealth v. Hallinan, 491 Mass, 730, page 736, note 9. Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are agencies, hospitals are facilities that have standards that comply, that are trustworthy, and this evidence should come in pursuant to those cases in that statute.
All right, now I'll hear you, Mr. Alessi.
Thank you, Your Honor. Attorney Brennan misstates our position that is clearly set forth in our papers. We are not citing to statutes that discuss consent of Ms. Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said that the results are reliable. And I appreciate very much that he has raised that, because not only is there no proof that the results are reliable, there's proofs in the first trial admissions as by Mr. Roberts, as well as impliedly by Ms. Knowles, that they're not reliable. And here's why. There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical records in the chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients. And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings. And the issue with regard to the reliability of the testing is it is not stated the basics to go to reliability. Specifically, there's no documentation of how the alcohol test result was obtained, through what procedure, by whom, and the key, what manner of testing. There's two ways to do it: gas chromatography and enzymatic testing. And there's a huge difference in the reliability between the two. There is no record evidence, and it's the Commonwealth's burden of proof to establish reliability. There's no evidence of any of those foundational aspects with regard to the testing. So with regard to those test results, the Commonwealth has to establish the reliability. It is not enough for the attorney for the Commonwealth to simply to stand up and ipsy dixit in saying they're reliable when there is a lack of the information of the factors I just rehearsed with regard to the matter. And another key aspect, which is conceded by the Commonwealth, they concede that the testing did not occur at an accredited laboratory. They concede it. And it's in every single report of the Commonwealth. And we put that in Exhibit A to our motion. For example, it's Exhibit A, the very first page, COM 000994, serum plasma conversion report. It states, 2 paragraphs under the chart, with an asterisk, the ethanol result used in this serum plasma conversion report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. Not the words of the defense.
So that's from the State Police Crime Lab, right?
Pardon me?
That's from the State Police Crime Lab, right?
That's correct. And with regard to the next document, which is our Exhibit B, in terms of changing that conclusion in that statement, there is nothing in there to remedy that statement. Exhibit C also mentions, and this is NDAO 296, under background, it's the same statement. The ethanol result used in this retrograde extrapolation report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory. So what we have with regard to the foundation of reliability, we don't know what type of test result this third party did, gas chromatography or enzymatic, and we don't know any of the other factors, and it's the burden of the Commonwealth to establish the reliability of that testing. So in conclusion, Your Honor, given that the Commonwealth has not satisfied its burden in this regard, the testing that has been performed is not reliable.
All right.
It should be excluded.
Okay. Do you want to respond, Mr. Brennan?
I would suggest the court look to Dr. Fowler's testimony. He testified how blood was taken, how it was preserved, what tests were conducted in the lab at Good Samaritan Hospital, how the lab is accredited. And this is the same issue argued at the first trial, but inevitably Dr. Fowler's testimony is what establishes the foundation for the admissibility.
Okay.
May I just respond briefly?
Sure.
Thank you, Hunter. Your Honor has often said that this is a new trial. The Commonwealth for this trial has to establish that foundation. They can't point to the testimony in another trial to establish it. That should have been in their motion in opposition, that they should have put that in, assuming that that is accurate. But it is not in their motion here, and that cannot be relied upon to defend the lack of reliability with regard to those factors. And I will also note that none of the witnesses I just rehearsed, Mr. Roberts nor Ms. Knowles, if we're going to talk about the first trial, ever referenced that as curative of what they said for lack of accreditation. And if we're again going to go back to testimony of the first trial, Mr. Roberts on cross-examination clearly expressed concerns with regard to these foundational absences with regard to testing. Thank you.
Okay. I think we have time for one last motion before we take the morning recess. Paper number 574, defendant's motion eliminate to exclude witnesses' prior criminal history. Who's arguing that for the defense? Is there no objection to this? This is regarding Richard Green.
It doesn't qualify pursuant to the statute.
All right, that was my question to you. How do you expect to get it in?
I don't.
Okay. All right, so this motion is allowed. That's 574 is allowed, Mr. Clerk. All right, so what I'll do is I'll see counsel at sidebar regarding scheduling.
Good morning, Matt.
Good morning.
Morning. Regarding scheduling, is this? Are we gonna? She said a recess, so I'm just curious. There's more to come today, right? I mean, she said.
Yeah, I think so. I think she's probably just like, are we going to be able to do this in the next 2 days, and which ones are important, and which ones, you know, are going to spill over.
So a lot of interesting stuff today. You want to react to any of it?
I mean, I think that, you know, no action on the deliberate misrepresentation of ARCA is a little ridiculous. I mean, it's really weak. Like no action whatsoever. Like maybe don't take that pro hoc vice away, but like nothing. Like, is she a joke? I mean, she's just so weak. It's like pathetic. It really is. And I mean, I know that a lot of people go after her about being pro prosecution, and that's so not true. She is so pro defense. She was a defense attorney. So it's kind of like, I don't know. I just think it was actually ridiculous. Like she could exclude them. She could do something. But she did nothing. So
I think her options were very limited. There will be sanctions imposed after the trial. I just think that at this point, it would be a very unlikely decision for her to take off any of these attorneys because it would result in a very long postponement of the trial. And she doesn't want to do that. And as we've seen in other cases, so for instance, in the Richard Allen trial, the judge removed his counsels because of the leaking of the crime scene photos of the girls' bodies. That's a pretty egregious offense. And so that's, you know, that she had good cause to remove them. But I watched that Supreme that SJC hearing when the
didn't Karen leak crime scene photos though, like to Turtle Boy,
yeah, which is different. But yeah, so there's just when you watch that hearing, it really is compelling that these states are not going to want to take away the preferred lawyers of a defense counsel of a defendant for murder, and so I just never thought that was going to be the solution here, and I don't think Hank thought it was either or wanted that. I think his goal was a long game, and what he's trying to do ultimately, and this hasn't been decided yet, and I think the judge is going to do this, though. She's, again, going to not allow mention of the federal investigation, and this time she's not going to allow the defense to portray ARCA as independent. I'm not a lawyer, so I could be wrong, but I've been predicting for a few months that that's what the real game was afoot, and if it was, I think it's well played by Hank Brennan, you know?
I mean, I just think the judge is just not changing enough things. Like if you look at like the Menendez trial, like how drastically that changed between the two, because the judge saw I made all these mistakes. That's why it was a mistrial. Right. And not that I'm on a certain side of that, but just saying like in this case, she's just so weak. She's not really holding them accountable for all the stuff they've done. They lied throughout the entire thing, had this media circus, and she let all the witnesses get harassed. She is like the worst judge I've ever seen.
Was Hank Brennan a little bit surprisingly understated there in his response to about the witness intimidation stuff? I thought he was really going to lay out some evidence there because they have so much direct evidence of this. And the fact that a grand jury didn't indict is not like Alan Jackson is trying to imply, meaning that it clears her. Not at all, you know? So
I feel like he, in some of these cases, he's just trying to get them to like commit to something on the record, so that when it does come down to it, I mean, I think he's going to get it in. Like, I'm pretty sure he's just saying it's not part of like the case in chief, which means he's not going to bring it up in opening and closing. But
Right.
I'm sure that he's going to get it in through the witnesses.
yeah, because they already mentioned in a motion last week that they want to get in evidence from Cosgrove, so regarding Turtle Boy, in order to introduce Karen's consciousness of guilt. So I was kind of surprised that didn't get brought up here. Maybe that's going to get, obviously it's going to get brought up later in that motion, but it almost seems to contradict what he was saying there. Like, oh,
Right.
we don't intend to bring this up. So
Yeah. And then the Aruba's not getting brought up. Like, that's strange.
yeah, I didn't think, I thought that was going to be the case. Well, and I think it's a good idea, but people will disagree on that. But I think it's better to streamline this case and stick to the fundamental evidence. Oh, they're going to break, so we can stay
You
on.
are muted.
I don't know. And I mean, it's just like the documentary that she's like, Karen is the dumbest defendant I've ever seen in my life. Like, she could have easily skated by on this. Like, it even gotten like a very light sentence. But she decided to create a circus because she's a narcissist. And like, that documentary didn't do her any favors. She looks like an idiot.
No, it hasn't yet. We'll see where it ultimately goes. I have not. Have you seen a whole? Did you get a preview for the whole episode?
No,
of the
I,
thing, or?
I haven't seen the whole thing, but it's just, and I feel like it's pro Karen. Like, if you think about like the facts, like they're not laying out a lot of the evidence yet. So it is pro Karen, but she is just so unlikable. She makes my skin crawl. Like, you
Right.
can just tell she's lying. She changes the story every 5 minutes. She has no remorse. She's just a disgusting human being. And like, that's what's going to do her in more than the evidence and more than what she did in this case. It's like that she is stomping all over the victim's family. She's gross.
Did you take any new evidence or insights from the documentary last night?
I mean, the glass in his nose, like, that was like shocking because, okay, now we know he didn't get in a fight, right? Unless
Why
like,
would you say, I'm still baffled because I don't think she's an idiot. She's not an idiot.
I think
So
she
there
is
must
an
be some
idiot.
I mean, there must be some reason that she mentioned that, but I can't speculate at this point on why. You know, is there some new evidence that's coming out? I don't know. Because if you get in a fight in the house, you're not going to end up with glass in your nose.
I know. Do police officers in Boston throw glasses at each other? Is that how they fight in Boston? Like,
I've
what
been
is
in
she
the middle
talking
of
about?
1,000 fights, and I'm not even exaggerating because that was my job. And I've had bottles thrown at me. But I've never been in the middle of a fight. I've been around plenty of broken glass in some of the big brawls, but I've never seen a piece of shard end up in somebody's face. So I don't really
Right.
understand why she was even telling it. But there's probably some reason, though. You know,
That happens in car accidents, though.
Yeah, exactly, and especially I would think that if it is a true story on account of the glass being there, John's got the cocktail glass in his hand, and that hand snaps into the back of the car on the panel, leaving that dent. And the car is a 6,000-pound vehicle going 24 miles an hour. So that doesn't surprise me that once it smashes that glass, some of those pieces are airborne and they might stick in his face. So it really seems strange to me that she mentioned that.
Yeah, it must have been before the medical examiner's testimony. She might have thought that
really?
injury was going to
Yeah.
get brought up, you know?
Excellent point. That's excellent point because
She didn't realize how bad
Yeah.
Scorty Bello was going to be. Because Scorty Bello, it was a joke. Like, she shouldn't even have her job.
And the criminologist talked about the glass too. That's you know what? I think you're on to something, Matt, because Kate's here too. Let me bring in Kate. Good morning, Kate.
Good morning. Sorry, I had to chime in because I was discussing this glass piece in the nose revelation, accusation, whatever, with someone who was on the scene that day. I'll put it that way, right? Civilian.
Yeah.
And I was told that was a lie, that never happened. right? And if you think about it, it was freezing, and she's saying that he's gushing blood, and that's usually, your blood's probably pretty coagulated, particularly with the cold. So I don't know if maybe
Not to
they-
mention that his heart didn't. I think you have your speaker on, Kate.
Oh, sorry.
Not to mention that his heart wasn't beating. So I don't know, but I wouldn't say that it's impossible that blood couldn't come out. You'd have to have a doctor talk about it. But I think Matt is onto something here, that maybe she, I don't know. This would have been recorded presumably in April, and at that point she should have had the glass testimony. But did she think that there was, for instance, I don't think they found. You know what? They found a piece of DNA. It was found on the cocktail glass, right? Not on the piece of glass. Where was John's DNA found?
I don't even remember.
I think it was found on the glass.
On the glass
possibly
itself, as I thought.
I think what I interpret drank from the glass, which she has now taken responsibility for too.
Right. The full glass of her vodka soda sitting in her cup holder. Like, what in the hell is she talking about? She is the dumbest person I've ever. I don't even understand.
I have to agree. I'm sorry. I know that she's touted as being very intellectual. She's clearly educated. I'm not going to take away from that. But as far as like actual common sense, intelligence, self-preservation, zero, zip, nada.
Well, I think one thing with the glass could be this. Now, obviously, we can see on the waterfall video that it's John that walks out with the glass. But John is a Bud Light drinker. So it makes sense to me that he was walking out with Karen's drink. Maybe she didn't want to finish it, but she could potentially use that to say that crosses one of the drinks off the list. Like, all right, yes, I ordered that drink, but I didn't drink it.
And I think honestly, like if you read the report, and maybe I'm reading into this too much, but they describe the glass that she's drinking out of as a vase style. I believe she described that as well. And he's got a lowball glass in his hand when he leaves. And I believe I'm 90% certain that they describe it as being like half full or less than half full. Like it's not full. So like yet again, just another inexplicable apparent lie that Karen has told that doesn't help her at all. It just connects more to the crime scene.
I feel like there might be two glasses though, because wasn't the black straw like a tall straw that would be in a tall glass? It wasn't a rocks straw, like a little straw.
Yeah, I don't.
That's
so it didn't matter.
I don't think it was a rocks glass. It was like what we used to call a 14-ounce or 12-ounce pint glass. That's what it looked like to me. I don't know. I'm not sure, but it could have been a rocks glass because from looking at the trial, the base of the glass matches the base of a rocks glass. So Kate could be right on that. I remember looking that up in the trial. They listed in the inches. What was it, 5 inches or 5.5 inches? The base of the. I don't remember. I could be wrong on them, but they did list that. And at the time, I looked it up and I'm like that. Yeah, that matches a rocks glass. So Kate could be right on that.
I have to jump, but I'll be back on in a little bit.
Thank you, Matt. So I myself with. I don't believe that she ever says anything without some purpose. Now, that purpose may look odd now because the evidence that comes, like Matt said, this was recorded before the first trial. So, for example, all the way back when Gretchen Voss was interviewing Karen, and that's in July of 2023, Karen strangely tells a story with all three of her lawyers present that what was I saying? Oh, I'm sorry. That the taillight was missing pieces. In fact, it was missing pieces badly. She was afraid that it was going to affect the functionality of the car. She could see wires and stuff like that, and that she even pulled a piece out. So, why would you tell this story if you later on know that you want to say that your taillight was only cracked and not missing pieces? It was very strange, but it's obviously they hadn't figured that out at that early time. So what she was telling that story was I believe that she was trying to suggest that she pulled that piece out, dropped it in the driveway, and then when the state police didn't find it, when they searched it a few days later, they must be lying because she knows there was a glass piece there that was dropped there.
They took the pieces from the driveway and then planted them. I think that part of her problem is that she's trying to cover for so much evidence that she's losing track. I was just informed actually that there are some free Karen Reed people that are still trying to claim that the drinking glass came from in the house. So I guess she's fortunate that her supporters will bend logic for her, because again, like that to me was shocking for her
Yeah.
to. I mean, you are literally connecting yourself to a piece of physical evidence found at that crime scene, right?
Yeah. Yeah. And if it was in the house, why bring it outside?
Why have a
And
straw? Like,
why have a
like
straw?
a bar straw, right?
I could see if you had a straw, but how did that drink end up outside? If John was if that glass was from the inside of the house, and John was beat up inside the house and then later dragged outside, why would they throw the glass from inside the house, which would match him to the crime scene? I mean, that's absurd. Even if you want to go with the theory that John got beat up, what would make more sense is that, especially given that we know that he left the waterfall with a glass, is that he went into the house, got beat up, and then later on, they were the real killers figured they better put the glass outside with him.
Okay,
It
but
definitely
there's option C here. Sorry, but there's option C here, which is just say nothing, right? Like, I mean, if the Commonwealth can prove that the glass came from the bar, make them prove it. Don't connect those dots for them on a nationally televised freaking tell-all documentary. I mean, it's just like, this is retarded behavior. The same thing with she acknowledged that she was using, not only that she was using Natalie, although not by name, but she was using an intermediary to talk to Turtle Boy, but then goes a step further and goes, at some point I got nervous about the intermediary, so I just cut her out. Like, what were you nervous about, Karen? Again, like, can they prove that they've been talking? Yeah, they can.
Right.
Make them do it. Don't do it for them. I mean, this is just like, I don't think she's very smart. I don't.
So Alan Jackson, I'm sorry, Hank Brennan mentioned a court hearing later. This is the Turtle Boy hearing, I assume. Did you,
at noon, I think he's getting. What do you mean, the Turtle Boy hearing?
well, he mentioned an unrelated. I don't know. I don't want to quote it. Let me see if I wrote it down. But he mentioned. I don't. Again, I wish I had the quote. Another hearing later this afternoon, and as though it had some relevance here. I'm sorry. He said a motion in another courtroom is what he said.
Right. So that's they're constant. It's weird what they're trying to do, and I kind of chuckled sardonically about, they get this entire sort of reprimand, not sort of, a pretty strong reprimand about candor to the court at the top of the hearing, right? I was like, I bet they already have lies pre-written for today. And then they go in to this third party culprit thing, right? And they simultaneously want to completely distance themselves from Aiden Carney and claim we have no control over this. This has no input on this. This is not us. But then at the same time, they want to double back and continue to wink to this cooperative defense that they on paper say doesn't exist, right?
Right.
Like, it's just so dishonest.
And they want to call him vile. I did notice that, but what happened they described as vile, and they had no connection to it. But I thought it was just stunning too for Alan Jackson to actually tell a judge that the fact that a grand jury did not indict Karen is equated to clearing her of any involvement with Turtle Boy or any involvement with any of this stuff, even though plenty of they know evidence was submitted for that. It's just because a jury fails to indict somebody does not mean that that's not proof of innocence. It just wasn't enough.
There's probable cause enough to get a warrant. Okay. That is clearly still under investigation, and clearly there's information that's still coming out. Like that's, I mean, just from March, last March, when they did that grand jury to now, they still haven't gotten into Turtle Boy's phone. They're still playing kick the can down the road games. Sorry, and that is as of yesterday. They're still delaying the taint team search, and then every once in a while Turtle Boy will go up and cry about how they still haven't gotten into my phone, like, because he's delaying it, right? So like, I don't. Yeah, it's not a good argument in the sense that like this isn't over. Now, whether the timing, particularly with these delay games being played with the phone, works out for this trial, I don't know. It would be a lot better if they hadn't brought it to grand jury and it hadn't come back with no bill, right? But it was probably a short-sighted tactical error on the part of a special prosecutor Mello.
Mhm.
But like, yeah, it doesn't really change anything. There is a ton of evidence, and again, like they're looking really at the grand jury, and they're ignoring the fact that a judge signed off on a warrant. There was probable cause that she's involved in criminal behavior.
Right. Right. It's just amazing to hear this talked about openly in court. It was so, I mean, does the defense have a point of it was a little it seemed like the door being open to talking about that witness intimidation. The judge was quick to open that door, but I think that just reflects the practical reality that she understands what's going on here. But from a legal standpoint, was it a little bit quick? Maybe. Maybe.
I don't
I don't
know. I
know.
mean, a good solution to that is not engaging in the conspiracy to intimidate and harass every single witness, investigator, prosecutor, and judge involved in your prosecution. So I would say that's a self-made problem right there, and
I
they
mean,
opened the
there
door.
was
So
I was a little disappointed. There was such an opportunity, and I'm not criticizing because I'm not a lawyer, but I thought there was an opportunity for Hank Brennan to go into much more detail on that. I thought he might even
I
mention
agree.
how Yannetti had gone to the parking lot where Courtney Proctor was working. I mean, you know, I don't know which of these things are legally allowable because that's not necessarily proof of something, but it did happen. Yannetti doesn't deny it, and so and then all the communications between Turtle Boy and the attorneys and Karen, you can't just completely Hank did try to say you can't just be naive and distance yourself from that when clearly it's happening. But,
I would
proof
have
of
brought up
actually
the
connect.
warrant.
Yeah.
Again, probable cause exists somewhere right here on paper, right?
Mhm.
So there's probable cause that she was involved when we're talking about the lowest possible legal standard. There you go, right?
Yeah.
I don't know, but I'm not a lawyer either. I'm just a mid-grade idiot.
Did you notice last night, Karen? This stuck out to me, looking right at the camera and saying to Jen, basically, one of us is going to win here. Um,
Yeah, it was psychotic. Again, it just shows that she set up that dichotomy. I was there, Jen was there. It's either her or me.
Yeah. She said, either I'm going down or you are. She doesn't say she says you are. So she's addressing her directly, turning it into this like alpha female contest, which is really, really bizarre, but does kind of confirm. I don't know if you heard me saying it earlier. Turtle Boy, when he said that when he went to the lacrosse game, when he made those strange statements to Jen McCabe in the stands saying, did you think you could outsmart Karen Reed? He later said in his admin chat that it was Karen's was the one that told him to say that to her. It seemed a little weird, but now it seems kind of confirmed. That is how Karen looks at this, right?
I never thought it sounded weird. I thought it was completely plausible. The context in which he was making those statements, where he was making those statements, I think lend a lot of credence to him telling the truth. You know what I mean? Because it was a self-serving statement in one respect, but it's also damaging. I don't think many people are going to threaten to turn somebody else in for conspiracy where that would result in another crime for themselves unless there was some validity to it. And it just always tracked because you could tell she thinks that she's the smartest person in the room. This is a game. This is a competition. This is a job to her. I mean, she completely lacks empathy. She's devoid of all empathy. She's a little bit psychotic in that sense.
Yeah. Yeah. After Judge Cannoni this morning really laid into Alan Jackson and the defense being uncandid, misrepresenting facts, even in sidebar, but when she didn't remove them, Karen was up there smirking and smiling like she just won a big victory. Even Alan Jackson understood to look grave, because he had just been really hit pretty hard, but she didn't know any better. She's just up there smiling away like, yeah, like all
And I
cocky.
mean, again, that sidebar was sealed, so we don't know for sure, but I would probably bet the farm on that colloquy being related to waiving appeal, at least on that particular issue for ineffective counsel. So
Yep.
it's not a win. You gave something up, Karen, and
Yep.
a potentially pretty big something. So
Right. So, I mean, I don't know if you agree with me. So I've been predicting that this is where this was going, but ultimately the goal, and we won't know this until the judge makes these rulings closer to the trial. But she's going to say, I don't know, but she's going to, again, not allow the mention of the federal investigation. But I think she's going to add to that ARCA will not be able to be presented as independent experts. They'll just be presented as normal defense experts. Do you agree with me on that? I'm
think
I'm
it's
probably wrong.
I
I'm the
think
only
it's a
someone-
given. I mean, I think that, yeah, I mean, definitely she made a point that Hank was entitled to a full cross-examination. I don't think she's going to restrain the Commonwealth very much on that. They can't be presented as completely independent, unbiased experts because they're not.
Right.
Just point, that's not the truth. So
But
yeah,
they were presented that way last time. And the argument that
because nobody knew, and then Hank got it out, right? Nobody knew.
Yeah, but what the defense would say is this, that at the time they made their report on February 13th of last year, that at that time they had no communication with the defense and they still had the same conclusion. So therefore it was independent. But what Hank made stunningly clear in that motion that we read on the channel yesterday is that he's questioning, and for good reason, as good faith argument, as he said, the fact that the feds or the U.S. Attorney's Office at that time was in itself independent. And so therefore, kind of like a fruit of the poisonous tree thing, if the U.S. Attorney's Office is not truly independent here in their actions, then likewise the experts they hire are not going to be independent.
Yeah, no, I can see that.
Interesting to see. So you were mentioning this morning about doxing of a juror, and you want to comment on it at all? I haven't seen anything on this.
Yeah, I think it's absolutely ridiculous, but apparently I was alerted that the jury foreman's full name and some biographical information was released by Turtle Boy yesterday. Looks like in retribution for the Commonwealth's motion to expand the buffer zone. He seems to be blaming the foreman who, he was his name and identity was also impounded off those court documents that were filed, the motions. But apparently we don't respect that court order either. The guy's just such a menace. I don't understand why he's still in that courtroom, around walking free in society at this point. He's becoming a real threat to the integrity of the judicial process, particularly in this case, but potentially, really spiderweb out.
I want to respond to, I'm putting this comment up here for a second before I put this guy in timeout. So I don't know who this is. NCSHP retired. So some kind of retired. He says, Plevin, I was a state trooper for 30 years, investigated thousands of crashes. I cannot today, but would enjoy coming on your panel, me and you, and discuss the crash investigation. Bring it on. Well, I may be willing to do that, and you can email me. But stop being a piece of shit. If you want to talk to me respectfully, don't say Plevin, say Kevin, and don't say bring it on. So, state trooper, 30 years, investigate thousands of crashes. I don't know. Listen, the one thing that this case has taught us, Mr. Retired State Trooper, is that there's no shortage of insane former police officers and former law enforcement people that insert themselves into these cases for some kind of reason, whether they're trying to get some. So he's saying, I can't do it today. So here is probably someone who we can guess is trying to get himself on court TV, trying to get himself maybe picked in other cases, maybe won't be surprised next week this guy will have his own YouTube channel. And because he's claiming to be retired state trooper, he'll probably shoot up to 20,000 subscribers pretty quickly. But again, you're being disrespectful and you have no reason to be that way. So as far as I'm concerned, you're a piece of shit. Now I'm going to put you in timeout instead of, well, actually I can't because he's on somebody else's channel. He's either on Matt's or yours. He's commenting on YouTube.
I'm not streaming it. Yeah. But it's probably not actually a retired state trooper, just to be fair. I see that there's a stock photo of a cruiser there, which is a pretty good indication that this is just another resident of Delulu Island. There's a lot of them a lot of astronaut, physicists, doctor, police, troopers out there.
I got this guy that emailed me the first time after the first trial, and his name is Walter. I'll just give you that much. And he sounded respectful at first, and he said, I haven't followed this case. I'm not on anybody's side. I just the ARCA testimony was impressive to me, and I don't. He said he described himself as some kind of engineer, and he said, I believe that that is reasonable doubt. But pretty quickly, and I was just people that are like that I'm respectful to. But over the period of weeks, I learned that he was lying to me. Now I don't no way of knowing if he actually is an engineer, but his conversation, his emails that still keep coming, and I mostly delete them, became more and more agitated and insane. And it was clear that he had these powerful emotional opinions about Karen that had to go back long before. So he's a turtle rider. He's a free Karen Reed person that is pretending to be someone that was objective and probably pretending to be an engineer. And he's completely irrational. So yeah, these guys do come out of the woodwork and you don't really know what they are, what they really are, you know?
I'm
Um,
muted. Sorry. Yeah, no. The thing is that on the internet, you can pretend to be anything you want. You can pretend to
right.
be a retired state trooper. You can pretend to be a 20-year-old woman with an AI picture, even if you're a 51-year-old sexual deviant. So,
Mhm.
yeah, I take everything with a grain of salt, especially people who claim to be experts, because I mean, again, like, and this is, more for my channel, but I always kind of view skeptically, like, if you're so intellectual and qualified, you're such an expert, what are you doing hanging around here? That's how I feel about it most of the time. So
Right. Um, I don't know. Someone said, answer my allegations. Like, you guys think, I don't know what it is about people that don't understand basic fundamental processes in the world. Like, somebody thinks that I am talking to you and literally reading every single thing in chat. So, he said, so he or she said, answer my allegations. What? People make stupid allegations about me all the time. That I'm faking cancer and this and that. So, it's just crazy.
I just want to give a shout out to I read a lot of the comments, and what seems to be an old school mass show mafia moment is we already have a retired Dr. Police Trooper account in the chat. That was the quickest sock account fire up ever, and I love it. But
Yeah. Yeah. I'm just the thing is you don't have to be an accident reconstructionist to understand that the evidence here is not the kind of thing. Kevin, answer my random comment in chat from take a look at chat and see how fast it's scrolling. Do you really think I'm seeing every comment? I mean, are you that insane? And if you're insane enough to think that, then maybe I shouldn't waste my time with you, right? So, I mean, I'm trying to glance at chat and see certain things, but there's only so much you can see when it's rolling that fast like that, you know. Oh, so Kate, you had something you wanted to add on the glass thing. Did you already address that, or?
I did, yeah. Just that I was told that might be falsehood. Who knows? Again, like, that was obviously a frantic moment. So,
Yeah,
um, I think either way, it's an odd detail to throw in there. Like, you didn't
right.
have to, you didn't have to volunteer that. The same thing with like admitting to how much she drank. But again, like, she's trying to cover for a lot of evidence. So I guess once you start talking, it can become quite the quagmire really
Yeah,
quickly, right? Because you want to cover for how much you drank, but you have to account for drinking some because you're on camera. And also you have to explain why you were so fucked up in the morning that you couldn't determine whether or not you actually hit him. And you thought for several days that you might have. And then, oh
yeah,
my God, no, it was somebody else. Like, that's just a lot of, you have to explain why he was found, where he was found, how all the taillight pieces showed up, how broken your taillight was, because you have to acknowledge that, yeah, it was broken because she told a bunch of people about it and showed people, but you don't want to say it's too broken because you still have to say that the pieces were planted. It's just like it's a situation where I almost wonder if her attorneys, did they make her sign like a waiver or something? Like, we're not
yeah.
telling you to do it, but then again, probably not, because they're like involved in it. But it's just such a
Right.
like catastrophically terrible idea. And I know that I think people follow the narrative of these things and feel like, oh, well, they're giving air to her conspiracy theories, therefore this is good for her. But it's not. It's a lot like the Phelps situation, right? To where like they're going to introduce the controversy in the case for viewers, but like the evidence is going to lead where it is. And then in the middle of it, now you have this, withered freaking vodka hag just running her mouth about intimate details of her case right before her trial. It's just such a catastrophically terrible idea. I understand why she's upset about it, but she can't blame Terry. She can only blame
Right.
herself.
Right, and she supposedly hasn't even seen it yet either. So I mean, I don't think last night did too much damage to Karen. So I think, and I wouldn't expect it to either, because like you just
You
said,
should Google,
it,
not
and
Google, you should search the hashtag "a body on the snow" on Twitter. It's done a lot of damage to her public perception, right? Because, like, again, like her statements are so contradictory and shocking and detailed and fly in the face of this conspiracy that she's trying to build. I think it was pretty catastrophic. And not only that, but like
I
think
think
as
it
Matt
will
was
be,
saying,
Kate. But just to finish what I was trying to say, I don't believe. I think at the end it will be after we judge the 5-part episode. But in the early parts, the idea is to build intrigue. So if you were going to, and I'm not even saying I have no idea where it ends up, but just hypothetically, if you're going to come out and say, yeah, this is this trial here, Karen Reed, and it's an ordinary hit and run. She accuses something else and she stirred up a mob, but it's really just a hit and run. You're not going to let that out at the beginning because you want to create that intrigue. So I think, I'm not surprised that it did. I personally don't think it did a lot of damage to her, but it wasn't in the early episodes, but it really would have been a mistake for them to do it that way. You want to build the intrigue. I'm sorry, go ahead.
I think that right off the rip, it was pretty damaging, honestly. There's no good can come of this. And I'm sure, like, as you're saying, like, I mean, would you say that what's been released so far is good for her?
I don't think it really moved the needle one way or the other in terms of jury pool contamination or the public or any of that stuff. I think, it really just sets up the story. So it depends on where it's going to go for there. There are people that have followed it so closely that realize, oh, that's kind of a changing part of the story. That's a new addition to the story. But the regular people in the public wouldn't know that. So they wouldn't pick that up. I thought it was interesting that Yannetti seems to have changed his stance yet again on Steve Scalin to reflect a little bit more accurately, saying that Steve Scalin didn't actually give him any information and didn't have any information, that he was, only had theories. Scott.
So if you search the hashtag "body in the snow" on Twitter, if I just read off some of the first ones that pop up for me, right?
Okay. Yeah, good.
Watching a body in the snow and I can't contain myself. Angry face, pained face. That bitch. Hashtag Karen Reed.
Right.
Here's another one. Did that woman just mock the mother about her dead son? Jesus. Karen Reed can't behave like a normal person, and it's never been more apparent than right now that something is fundamentally wrong with her.
Right.
Has Karen Reed ever come out and told her fans to lay off John's family when taunting them when coming into the courtroom?
Right.
Worrying about what shoes you're wearing and being on TV when you're being arrested for second-degree murder is interesting. Like, I mean, These are new people. These are people that have, like, somebody else says that's just wrong to be booing John's family as they walk in the courthouse. Somebody new, completely, I've never seen this guy before, goes, when the reporter asks, so you didn't kill him? I would have, hell no, and don't ask me again. You got me fucked up right away. Her lawyer ended up having to say, no, she didn't do it for her. I mean, like, this is not good for her at all.
So why do you think Alan Jackson, I think we maybe mentioned this the other night, but why did he choose Terry? And also, why didn't they have, could they have had something contractual where they said you can't release this documentary until after the jury decides?
I think they're just full of hubris and narcissism, honestly. I think they thought they had an acquittal.
Yeah.
I think that they did this thinking that this would just elevate her post-trial. I wouldn't be so, and I'm sure that, like, the time frame that they probably originally agreed to, if they got an acquittal, the trial would have been, over for quite a while now. And this would have brought her back into the public focus. Because I think that Karen Reed's end goal here, although I'm sure acquittal is on the list, is probably even slightly below fame. Right?
Mm-hmm.
She wants to be famous. And I think that to people as vapid and narcissistic and short-sighted as she and her, or at least some of her legal defense team seem to be, all press is good press, right? It's sort of like OJ coming out and writing "If I Did It," because the spotlight starts to fade, right? I don't think she wanted that spotlight to fade. And I think, unfortunately for her plan for acquittal just didn't work out the way that she intended it to. And now it's off and rolling. And I would assume, we know because she confirmed. I know Terry tried to gloss it over and was the consummate professional or whatever, but Karen is confirmed. They're pissed off at Terry. That relationship broke down. And I know that it broke down well ahead of the release. I'll put it that way. So, I think that could have possibly been one of the points of contention is like, well, we agreed we're releasing it now and we're releasing it now. But just in general, like, this is not a good idea. I don't think it helps her at all. And, it looks like already 2 hours into this thing, it's hurting her, like publicly anyway.
Do you think it went down something like this? So I think I don't believe that Karen or the defense team, when they first started going to Turtle Boy, ever anticipated, it looks like we're going to get on a break soon, but they ever anticipated this mob. But then once it developed, they exploited it. All right, we'll come back to that later.
Yeah.
Thanks, Kate.
All right. So, Mr. Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long. I want to formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there's a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes,
Okay.
Martin Weinberg. If in fact the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action, that would set the trial into upheaval. If once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because it's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right. Do you have any timeline on that?
I wish I did. I don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, I believe that whoever it is that is appearing for the Commonwealth, or for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday, and then the reply brief would be to you 2 days hence. So the briefing is going to be done in relatively short order. The decision, that's another question.
All right. Thank you very much. Does it make sense for me to hear from Mr. Schillinger directly, or do you want to handle this, Mr. Brennan?
Thank you.
Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea how this works. So why don't you tell us?
Sure. So as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown. And the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly, if it were possible to have all of this resolved before moving forward, it would be ideal to know which charges are going to go forward and which wouldn't. At the same time, Commonwealth is obviously strongly opposed to moving the trial. And so, while perhaps unfair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members, and to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in, Your Honor's schedule. That would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss in the final pretrial conference is how long this case is expected to take. So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So I'll hear you all tomorrow on this then.
May we address the court at sidebar on one issue before you leave the bench?
Sure.
So the defense is trying to postpone the trial based on waiting for the appeal to the federal court, the federal circuit court, for the habeas corpus issue involving the jurors' supposed decision on counts 1 and 3. Supposedly, they unanimously were for acquittal on those two particular charges. This is not an argument that is likely to find purchase. So I don't know if the judge is going to weigh that. Hey, Matt.
Hey, I missed whatever was going on, but I was reading the chat. So who was that guy that was just speaking?
You know, that's a good question, and I didn't jump out by telling people who it is because I have no idea. He almost seems like a representative from the federal courts. I don't really know who he is.
Oh my God.
It wasn't introduced. I got his name, but that doesn't help us. He wasn't sitting with the prosecution, so it seems like he's somebody. He wasn't sitting with the defense either, so I don't know. But they're looking at some kind of postponement here, which causes all kinds of issues as she talks about with the jury impanelment, you've got a long process here to get a huge pool of potential jury members ready for April 1st. So
This is such a joke. Like, look at the O'Keefes. Like, they're like, can we please just be done with this? Like, I'm sick of looking at this ratchet woman's face. Like,
it's so hard to have to. I can't even imagine to have to sit on those benches every day. I couldn't do it.
All right. So we'll
She
see
loves it,
everybody back
too.
here, not tomorrow, but Thursday morning at 9 o'clock.
it's
That'll be
over?
the time, Mr. Schillinger, to speak with maybe Mr. Weinberg or counsel.
Well, thank you, Your Honor.
Okay, so see you Thursday. All right, thank you, everybody.
All right. So apparently, no hearing tomorrow. The hearing is on Thursday. Oh boy. They don't work around my schedule. I don't know about you, Matt, because I got an important meeting Thursday. I don't know.
so
The meeting's
Thursday, they'll be back. Okay.
Thursday. They'll be back to go over some of this stuff, and so man, now it hangs over us the possibility of a postponement.
But look how happy they are. Like, what? Like, this judge sucks. Like, she really is terrible. And I feel like she's watching all these like law tubers and trying to be so careful not to like step on the defense's toes. She's like the weakest judge I've ever seen. Like,
See, I don't
I
agree
just-
with that but I mean, it's so hard for us to tell because we're not lawyers, right? But for me, I think there's always going to be they don't see the prosecution. If they lose the case, it's over because of double jeopardy, so they can't appeal. But when any defendant loses, there are going to be appeals, especially in a murder case. So she's trying to just protect herself in this case from giving them any kind of a basis for appeal. I don't know. Well, Heather is here. Heather is our lawyer, our residence lawyer. Heather, what do you think? Am I making sense on that? That the judge is just being conservative like any judge for that reason? We'll see if Heather gives us an answer in chat. Am I way off, Heather?
is it Heather
need to get
Ann?
Yeah. We need to get a
She
lawyer
said-
in the room.
She said they know they're not winning this. So like they're just pulling out all the stops. I think if that's the lawyer.
Yeah.
Which I think that is true. I think they know. I mean, I think this documentary, they are just trying to like do everything they can to taint the jury pool, to create all these distractions from the facts, because the facts, are indisputable that she killed John O'Keefe, whether she had intent, whether she knew he was there. Like, that's the only question. And
Okay, I got an answer for you, Matt, from a lawyer, and I should have been able to figure this out, but I'm not smart enough. So, the guy who spoke, that guy earlier, his name was. No, I guess his name doesn't matter. It's some kind of. Yeah, I wrote it down somewhere, but it doesn't matter. But anyways, he is a lawyer for the Commonwealth. He's an appellate lawyer. So he is the one that is handling the habeas corpus argument for the state in court. So he's going up against Weinberg. And so that's why he's there to discuss it, to give feedback on that.
good Lord. I mean, that was always a joke though. Like, no jury, even the law tubers that are on her side always have said that is a joke. The jury can't just be like, oh, whoa, well, actually we decided after the fact. Like, imagine if that was the case, like every jury could just be like, can we do a do-over after like someone's convicted or not convicted? Like, it's the dumbest argument.
And it would just open up such a huge can of worms. I think there's a case to be made that maybe jury deliberations, it should be made more clear to the jury that you have the option of acquitting on certain charges. And I think there's a legitimate philosophical argument for that. But you're not going to get a reversal on this case. The judge didn't err at all, that she was going within the consistent practice of law for 2 centuries in this state. And presumably in other states the same way.
I don't actually think that the jury did acquit her on 2 charges. I mean, I just don't think, I just don't believe it. I think that they totally didn't agree with each other, and I think that they just only discussed the main one, whether she did it or not.
Yes.
Because how are you going to discuss the other ones if you can't even define whether she hit him or not, right? Then it goes into what was she thinking? Did she have intent? But they couldn't even get past that. So how would they decide on the other ones? Like, it doesn't make any sense.
Right. No, I totally agree. What I'm saying is not. I agree with you. I don't think that the jury voted to acquit, unlike what some of those jurors are trying to say now. They taking a temperature of the room vote when you first get into deliberations is not the same as actually voting on the charges.
Right.
It's normal when you're on a jury, when you first get into the room, you're going to do like a little temperature, take the temperature of the room, how people feel about it. So then you can decide where the differences are and you can focus on that. But there was no point in deciding whether or not there was any malicious intent or whether or not Karen left the scene of the accident until all 12 people agree that her Lexus actually struck John, and they never got to that
Right.
agreement. So, what is the judge going to do there? Is the judge going to, is she going to postpone the trial to wait for this?
Oh my God. It's just such a joke. Like, imagine, like, I don't know. I just think that Karen is like, and now she's doing these things and attacking Peggy O'Keefe in that documentary. She's just such a terrible person.
Yeah.
They should revoke her bail then. If they're gonna delay the trial, revoke her bail. That's the only way that I think is fair.
Let's, and there's another thing to consider too, is let's say there was a substantial postponement. Let's call it 2 months. Does this benefit the defense or the prosecution?
I mean, I could see ways that Hank could then start arguing to get this documentary into the trial, but it's like,
Right,
it depends
right.
on what, because the documentary just came out. I think this documentary is screwing her, and it's kind of in her favor, but she's so stupid that she doesn't know what to, like, I just don't even understand. It's like the most narcissistic person I've ever seen.
Yeah.
She's so full of herself, and she has like the turtle cult backing her, cheering her on, that she doesn't realize that normal people see her as a freaking maniac.
And she's going to blame Terry, who supposedly flipped on her, even though all Terry is doing is recording her words and putting them into the documentary. Now, that said, there is a degree of control within a documentary like that, because you got hundreds of hours of footage and you're choosing what to put in there. But did they really expect her to make a like a Richie Keough propaganda film? Is that,
They might have. I mean,
yeah, get that in writing then, dudes, or make sure you've worked at this. Make sure you've done a documentary with this person before, because Terry does Unsolved Mysteries. She's the owner of that. This is the first long length documentary series that she's done. So there was no other way they could look at her work and say, oh yeah, she just, if you give her this kind of access, she'll just give you what you want. There was no record for them to base that on,
I think what it is that she's had so much luck with the law tubers, because like the likes and clicks and views are for the conspiracy. And so her expectations and her reality is so distorted that she just thought like everyone is a grifter. Everyone is just going to jump on this because it's like the better side of the story and not tell the truth. That's what audience wants, and that's what they're going to do. And I think she's so deranged that she really, I don't even know what she thinks. Like she's so full of herself. She has no remorse, and she just like has such an attitude. I just don't understand it.
Yeah, I mean, the capacity for the human mind to believe things, we've seen this in many other kinds of situations, not just criminal cases. But, there's that cognitive dissonance thing. So when you have something in your head that is causing you a lot of mental anguish, then your brain might come up with other things, and it could be fantasies that lessen that anguish by buying into some false scenario here. And that could have happened here. I think, as I started to say before the break with Kate, I don't think Karen or her team foresaw this circus when they started going to Turtle Boy. Yes, they wanted to get their story out there, but they did not. Nobody could. I don't even think Turtle Boy could have envisioned this kind of circus that came about. But then once it did, they've exploited it, but they've also bought into it. And so at some point during that, when they could see these armies of people out there eventually in pink and say, oh, let's go get a documentary. And for Alan Jackson, he says, here's a chance to turn myself into a star, So it's not about when Jackson, his motive has nothing to do with Karen. It's like, here's my chance to turn I can become the epic star lawyer of this generation, And Karen is, like you said, buying into her own fantasy that she's this great person out fighting for justice and to reform the system and pretty soon she's going to be healing the sick and just buying into this fantasy. I don't know. Does that sound plausible?
I mean, so some of the stuff that her family said in the documentary, I was kind of shocked by. Like her brother saying, "Oh, she wasn't really that sad," and she was just like, "Dad, what's the plan?" And I'm like,
Yeah.
"Exactly. That is exactly what happened. Dad, what's the plan? I'm not going to say that I did this." Like, it's so unbelievable. Like that family is so demented.
He actually used, I had to give him, just from a writing point of view, he had a cool twist of phrase, something like Karen didn't get lost in loss or something like that.
Yeah, she doesn't
I
get
appreciated
lost in the loss.
She
or
didn't
something.
get lost in loss, and so she came out fighting. I gotta give him credit for a clever twist of phrase there. That guy, I don't like that. Just something about that guy's face that really bothers me.
Space.
So it's not. I'm not trying. Well, the thing was, my first. You know what? It didn't. And I don't usually say things like that, but when I went to Dedham, and for the first time for one of these hearings, and your parents were there, and so when Karen's entourage arrived and they went up the stairs, there was, this was the day there was probably 100 people there for the Blues and maybe 500 people there for the Pinks. And so obviously now the stars arrived and the lawyers and everything. It's, people are cheering and booing and all kinds of bullhorns are going. Then it was about a minute later that Nathan arrived. He actually arrived separately. And so he comes, now they come up the sidewalk through the Pink crowd and the Blues are on the other side of the stairs. And he walks up the stairs and he looks down to see, like stunned, to see all these blue shirts. But he stops at the top of the stairs to just sneer at, like the most ridiculous sneer I've ever seen, like sneering at the people at the Blues. And I was like, that was the moment I said, I can't stand this punk. If I still owned a bar, I'd find a reason to throw that guy out just for that sneer.
I don't know. It's just so, like that documentary, I feel like they're not even really saying she's innocent. Like I just didn't even get that from it. It's like, oh, the only thing so far is like the Google search, right?
Yeah.
But we know that's debunked. Like if you know the case, it's debunked.
Right.
But
right.
And then she's like saying, oh, well, it's either me or Jen McCabe going down. Like, what the hell is she talking about? Jen McCabe was never implicated in running him over or beating him up. Like, what is she talking about?
It was really weird. And she even said you, like to Jen McCabe, like she's talking directly to Jen McCabe. It's like
she's psychotic.
Yeah, it really is unusual. And Jen hasn't said anything like that I know of either. She hasn't turned it into this weird personal pissing contest between them. And Jen would have every reason to be extremely angry at Karen for what Karen has done to her and her family. Incredibly angry. But yeah, it's perplexing behavior at best. Let's what else is in the so. In that documentary, just a few quick notes from last night you can respond to. Alan Jackson said, jury selection, that's the trial. Of course, this is before the first trial he said that, but shows you where their focus is, right?
Yeah. I mean, I believe it. They want cop haters. They want conspiracy theorists. They want, the pink slime people. That's the people that they know what they look like. They're the ugliest people in Massachusetts wearing pink shirts. Like, that's what her cult is. And like every time she's like, oh, this is my purpose in life. Like, what the hell are you talking about? What is your purpose in life? You got the ugliest people in the country to dress in pink. Like, what did you do? She has done nothing. She's such a lunatic.
Yeah,
it's
crazy.
I can't. Like, every time she opens her mouth, it gets worse. Because, like, at first I felt bad for her. And I didn't even want to speak on the side of she did it. Until I saw like people like harassing the family walking into court and then her actions. And then I'm like, what is wrong with this woman? Like, she is nuts.
Yeah, there's definitely some very unusual behavior there. But at the end of the day, the jury will weigh evidence, of course. And that's as they should do. What did you so I'm curious about that. You not being a lawyer, you probably don't know much about this either, but I'm really curious about this impanelment voir dire that Alan Jackson wants, and apparently is the norm in California. And the judge said she is in favor of that too, just not in this case because of the the publicity around it. So what goes on in an impanelment voir dire? Do they ask questions to the group in mass? Is the cameras in the room? I mean, what do you think goes on there?
I'm not sure. Because I know that they definitely have a set of questions that they can ask, but in impanelment voir dire, I'm not sure. It just seems like it's a lot more extensive.
Right.
Whether I have no idea. But it seems like they want to get down to like the details. Have you ever been drinking and driving? Which most people in Massachusetts probably have, because, especially older people, because Ubers weren't really a thing. And a lot of these small towns, you can't get a taxi. You can't, like, a lot of people have drink and drive. So a lot of people will empathize with that.
Kyle points out that the judge denied that, but which she did, but I'm just curious as to what it is and how that works. I don't know. It's just interesting because we know there's a sidebar voir dire, like she says. So first the juries get the 1-page questionnaire that they have to fill out. And then I believe each juror, as going through this process, goes up to the judges, the bench, and the judge and the lawyers get to look at the questionnaire and then get to ask individual questions to this juror. And how does that different, though, between this panel voir dire? I mean, panel implies that they're together, right? So, curious about that. Well, maybe
I feel
one
like
of the lawyers message me.
It does sound like it's like, I don't know, like what I would think is like you want to be able to, it sounds like they want to be able to see other people's reactions to answers. So are they going to ask them and they're going to answer in front of other people and they see how people react? They're really trying to find the pink people to be on the jury. Like, that's what it is. They want a tainted jury pool. Like, that's their only hope. I just can't. These people are the worst.
Thank you, Grace. I appreciate it. I just responded to a comment. Grace, thank you. I'm trying to do the best as I can to be honest and objective about each particular issue. It's a temptation on the part of all of us to, once we have a perceived side or decisions in your mind, to look there for it. Every, confirmation bias, every other piece of evidence or thing that happens or testimony or person on what side they are, you put them into that box. So everybody on the other side automatically hates Hank Brennan. He's a bad guy. And everybody on this side automatically hates Alessi. He's a bad guy. And it just, I try to avoid that and try to look at each piece of evidence and each thing that goes on objectively and independently. But I'm just curious what goes on with this panel voir dire, because the defense clearly wanted it and thought there was some advantage in it for them. The judge said, no, that's really not going to be allowed here because of the publicity on this case. And, the prosecution didn't want it. They wanted to go with the questions. So I'd like to find out more about that. Hopefully one of our lawyers will email me about this.
I feel like it's a way to get them harassed, because like they're going to know who answered what. And like the ones that get released are going to know. They're going to go to Turtle Boy and they're going to be like, that person said this or whatever.
So if that's the case, if we can't find a legitimate argument that a lawyer is going to send to me as to why this would be an advantage for the defense, then we're going to go with Matt's answer here as a default and say that's really fucking scummy. That the only reason you want an impanelment voir dire is because you want to create more pressure on those individual jurors, and that's just that. Again, that affirms that that's exactly what is going on, despite Alan Jackson's denials here, that they are trying to intimidate. They're trying to intimidate not only the witnesses, but the jurors. And so one of our regulars asked who you are. I said, this is Matt Doherty from Boundless Millennial. His channel is on YouTube and perhaps still on TikTok, Boundless Millennial. And he's kind of one of the OGs in this case who started flipping on this late July of 2023. So one of the earliest people to flip on this case, deciding that the logic of the conspiracy theory just didn't make any sense.
I think
something.
I was like, I guess in the beginning it was like Turtle Boy was the only one covering it. Maybe there were, I don't know, but I like started like looking into it, and that was the kind of stuff that I covered, right? So on TikTok, and then I looked into it and I was like, oh my God, it's bullshit. I got a few documents. I think it was the original affidavit and then the defense's response. And like in the defense's response, it was like Rick Green stuff, saying he's going up and down stairs, but like they released it as if it was while he was at the house. But even in Rick Green's original report, it says it happened before they ever arrived at Fairview. So it's like, how are they like misconstruing that piece?
Right.
And like everything just fell apart from there, because like every single thing that you looked at in that original April 2023 defense filing was bullshit. But they argued it in a very like, you know, conspiracy laden way that the public responded to. And I was like, oh wow, this is bullshit. And then
If
I
I
had
remember
like
right,
that
that
discussion with
report
Turtle Boy.
You're correct in that report, and if I remember right, it allowed some weirdly short amount of time, like say 17 seconds, where John could have gone in the house, got up and down 3 flights of stairs, and got beat up. Again, John didn't go in the house, and that I'm saying, but according to Rich Green's version, so that they arrived at this time, and the health app began showing the stair climbing at like say 12:22, and the period that ended was like 12:24 and maybe like 28 seconds or something weird like that, and it allowed just there was a tiny window within there, which made no sense at all, but that was something that Turtle obviously ignored, you know.
Even in the trial, I don't think that they even disputed. They never even got him in the house in the trial, like even with Rick Green on the stand, because they kind of wanted to dispute like the timeline. But even if the times were off, he only had like a second where his like thing was even touching the front door, like because it was like a 50 feet radius of where he could be on his GPS. And there was only like 2 seconds that he was even touching the front door. So even if the times were off, it's like, he didn't go in the house. Like he went to the front door, and that's why she always never said he went inside. That's why she was always like, he went up to the front door, went in the threshold, because she knew that's what it showed. She knew that his GPS didn't go in, but it still doesn't answer anything.
So I guess maybe the jury impanelment like this would go like this. So you have 100 jurors in the room, in the court, and 100 prospective jurors in the court, and now you ask them as a group, have you followed this in the media? Have you, so instead of the typical questions that they get in the questionnaire, you would have you followed this in the media? You're asking them to a group. So now somebody has to raise their hands and say, yes, I did. That's a much, much harder thing to do. Someone's much more likely to way more likely to sneak through that. And this has already been a huge problem in this case where people snuck through in this jury. So it's one thing to just stay silent when you're in 100 people and you're asked a question like that. But it's a whole other thing to stand before a judge and the lawyers, but in particular, that judge is sitting on that bench looking down on you, and she is authority. She is the law, and you feel it, because I've been on a couple of juries. And
not this judge, though. She doesn't really hold anyone accountable, so like you can say whatever the fuck you want.
Yeah,
like she's not going to hold a juror accountable. Like, are you kidding me? She doesn't do anything. She lets them do whatever they want.
But I just saying it's a lot harder for a prospective juror to say, nope, I didn't follow this in the case. I did not form any conclusions on this case. It's a lot harder for them to look at a judge and lie when they're asked eye to eye than it is to just say it, to hide yourself in a group. Does that make sense? Or
yeah, I mean, I think that's true, but I also think that these people, like even having conversations with them on Twitter or whatever, they shift shape. They don't really have a stance. They don't even know what happened. They don't even have a theory anymore. Like all of the theories have been debunked, so it's like they don't even know. They just want Karen to get away with murder.
Right.
That's it.
Right.
And it's gross.
The show must go on. The circus outside. I mean, they're probably this time they're going to have jugglers and vendors, and it's a party out there. Boom boxes and music and dance contests, and they already got plenty of dancing out there. It's the last time there was an artist out there doing captions and stuff like that. And I'm not trying to attack her, but I mean, it's just you're turning this into a circus. And
I mean, we should go there with a piñata with Karen Reed's face on it, fill it with little Tito schnips, and let Jen McCabe beat it. That's what we should do outside the next trial.
This is Dedham. If you've got a piñata out there with nips on it, it's not going to last long. I'm telling you, there's going to be a fight. All sides are going to be, but maybe they'll all come together after that. After they start drinking nips, like who cares about the trial, But actually, when I was out there last time, when I was out there in Dedham for the court TV shoot, While Vinny, after I had done my segment and Vinny was up there, had other guests on, I was talking to some people in the back, and it was in a restaurant that didn't have a bar or a liquor license. And so I met some people, including from the other side. And to be friendly, I'm like, hey, I said, hey, I had heard of them. I was like, I'd buy you guys all around a beer, but this place doesn't have a liquor license. So it was an easy way to offer to buy a round and not have to buy one, right? But so I bought actually some ribs, and I went down and I introduced myself to Nick Rocco, and one of Karen's bodyguards was with him, and I shook his hand, and I offered them some food. And so while I'm sitting there, somebody who is on the defense witness list but didn't testify, and I had just met, and she was one of the ones that I had just offered to buy that drink for, she came over and she put a Jack Daniel's nip in front of me. And I said, oh, thank you. I said, where'd you get that? She pointed to this big stuffed bag that was on the table. She goes, I brought a Canton bag with me. So they actually had a word for it, a Canton bag. So it's such a common thing for these guys to bring a bag full of nips to any event. I mean, and that thing was so full. That was an instant Super Bowl party if they wanted. I mean, it was just. So she brought me over another one. I finished that one. She brought me over another one. I was like, oh boy, I can't hang with these guys anymore.
So I saw something with the DUI guy was saying there was some bombshell coming this week, and I think that what just happened is probably it.
Which
He's
part?
like, just wait, guys. The feds and whatever this whole thing was where the trial might be delayed. I'm thinking that this was probably the bombshell he was talking about, that he knew about.
Yeah. Let's see. Nothing else really came up today that could have been bombshell, right? Yeah, I guess that's probably it. I mean, the effort to try to get rid of the blood evidence seems, the blood alcohol stuff, it was allowed first trial. It's going to be allowed. The effort to get rid of Dr. Wolf for the accident the neurologist for the state. I mean, come on, that guy is as qualified as anybody could be. I mean, it was just ridiculous. It was just wasted breath today. I thought. Do you agree with that? Or
Yeah, I mean, I don't remember which guy, but I remember on the witness list there is one missing that was, I thought it was the expoliation guy, that wasn't on the Commonwealth's witness list. So I don't know if they had a couple people say it. I don't remember that day. I remember that was a boring day of testimony where all the doctors at the hospital were there. So I don't know. Maybe they just have one less. Maybe it was more than one that said the same thing. I don't remember.
Oh boy. All right. I'm just looking at the crazy comments in chat. All right. Anything else you want to go into, or it's time to call it a day, and we'll be back Thursday. Anything else you want to go into though?
The one thing that I just want to note from that documentary is they did Lally so dirty with showing the clock while he was doing his opening statements. I was like, oh my God, they are dragging him so hard.
Oh my God. But and I had, people, some of the people on this side got a little upset with me in Discord last night, but because I posted, I said, you know what? I respect Lally and I'm rooting for him. And he worked really hard, and I think he's an honest, decent public servant. I said, but then I still feel frustration for this. I mean, his opening statement was so bad.
It was.
That,
it was bad.
That the defense and Karen was celebrating it on the way home.
Mm-hmm.
I mean, how bad can it be that you can't even get the opening statement right? And it's just, he did not give a roadmap for the jury, because so the jury if that's needed in every case, but if there's ever was a case that a roadmap was needed, it was this one, because we didn't even learn the state's theory about what happened until 9 weeks into the trial. So
yeah, this is a complicated case too, with so many different witnesses. They're not going to remember all their names. What the hell are you talking about? And I don't know, but if Arca wasn't in the trial, if the feds didn't intervene, Lally would have got his conviction. So even with that, even with the parts that he might have mucked up a little bit, he still would have got a conviction if it wasn't for the feds intervening. So
right, and he did some parts well. I think he did a very good job of debunking the conspiracy theory. He just didn't do a good job of laying out the state's case. So whether it was just too much burden on one person, I know he had a little bit of a team with him, but he just really, I didn't have a big problem with his style or anything like that, it could be tedious, but there's a benefit to that nuts and bolts kind of strategy where the juror looks at this guy and says, he's just a man of the people. He's just doing his job. And so I
Right.
just think the strategy that they had was really bad. And so somebody could have saved him, maybe Hank if they had him back then, or just Morrissey. Isn't that what your job is supposed to be, the DA? This is the most important case in your time's history. Can't you sit down and help this guy come up with an opening statement, a closing argument that you actually don't run out of time for? I mean, a strategy that involves proving your case, and most importantly, reminds you to spend a lot of time with your most important witness, your accident reconstructionist, Trooper Paul. They spent one day with him. And it's just, you mastered wall files, great, but a lot more needed to be done.
Mm-hmm. Yeah, she's screwed now.
Yeah. Yeah, no, I think Hank's on target. He seemed a little low energy today. Maybe he's feeling a little underwear. Maybe he ran into somebody last night with a Canton bag. I don't know. But all right. Well, thank you very much, Matt. Great as always, and hopefully you can join us Thursday. If apparently the next hearing is Thursday now, it's not going to be Wednesday.
All right, sounds good.
All right.
Thanks
Matt.
guys. All right, bye.
All right, guys. So we'll just wrap it up there. It's time for lunch. Thank you, everybody, for being here. We do get a little bit more of a mix of people coming in that are from the quote unquote other side, and they're always welcome here. Just be respectful. You don't get on. If you want to engage me, great. Do it politely. Do it respectfully. Tell me your argument. Tell me your evidence. And if you are an accident reconstructionist or a lawyer or former law enforcement, yeah, reach out to me. My email is leitskev, Leits, leitskev @gmail.com. And maybe we can arrange that. So, but be respectful. There's no reason not to be. It's why would you basically say, hey, asshole, you want to debate me and you really think you're going to get a response out of me? That's not going to work very well. So, but everybody, the weather is really improving. It's a little cooler today, and I think we have an inch of snow coming Friday. But as far as Thursday, I have a meeting Thursday, but I don't think that'll interfere with this, or at the very least, I'll be able to get this started. And as of now, there's nothing scheduled for Friday. I have medical scans going on Friday, and so I suppose if they had something that went on at 9:00 in the morning, I would start it here. But as of now, there's nothing scheduled for Friday anyways. So, I might say thank you to the people like TYJ. Thank you very much for the donation. And Alma with a super sticker, always being generous. Thank you very much. Ashley asked if I'm covering Aiden's hearing. No, nothing ever happens there. That I am convinced that the apocalypse will come and end, and we still won't know what's inside Aiden's phone. Without being disrespectful to this state, some of it seems like a goddamn joke. It's been over a year. There's no reason to deny access to that phone. You've had the taint team go through it. I don't understand what's going on here. Is it the fault of the judge, the prosecution? I don't know, but it's just bizarre. You're just going to have this endless stream of hearings that go nowhere. What is the point? If that's all you're going to do, then just let them go, because you're not really prosecuting a case. You're just doing something weird. It's like busy work for lawyers, I guess. I don't know. It's just amazing to me. No strays ent says on the dock last night, Karen said she watched John O'Keefe walk inside, but also said maybe John tapped the back of the car. How can these two things be possible? Right. But what she is actually saying is that people get this mixed up a lot. When she says, did I run over his foot? Did I clip him? She's not saying that she thinks now that that's what happened, or that she thought at the time that that's what happened, at the time of the accident or whatever. What she's saying is that morning when she got to the crime scene and made some apparently incriminating statements about herself, that what was going on in her head was she knew that John was hurt, and she was asking herself these questions at the time. Could I have hit him? Could there be some way that I somehow did something and and he ended up lying there unconscious and dying in the cold? That's what she's saying. She's not crazy enough, or she's not stupid. She's not going to get up there and say, "Yeah, I remember hitting him, but I just didn't think it was that hard." Even if that was the truth, she wouldn't say it because it would be so self-incriminatory that it would be ridiculous. So it's not what she's saying. So I think that's where the difference is. So that's what she's explaining about. Did he tap the back of the car or something like that? It's a little bit odd there because now she's wondering, is that how she's trying to inject this idea that is that how the taillight got broken, which is a little bit new and different. So good job in pointing that out. And Macy became a YouTube member again. I believe Macy's been a member before, but welcome back, Macy. Heisenberg, haven't seen you in a while. Thank you very much. He says TB doesn't even have feelings for his girlfriend. No, or his family members. A psychopath doesn't generally have emotional empathy with anyone else. So the feelings they have are very shallow and simple. So is what it is. All right, guys. Thank you very much for being here. And so if there's always a chance you'll see me tonight or tomorrow night. As of now, I am going on Court TV tonight, and on Court TV, well, they've got it scheduled for Wednesday, but maybe they'll change that now that the hearing is Thursday. So we'll see. So if they change that, then maybe I would go live on the air here Wednesday, tomorrow night. But we'll also be watching that documentary. And but hopefully we'll see. I think we're still a month away, but I can't wait for the trees to bloom. It is nice where sometimes you can open your window. Yesterday, last couple of days was in the 60s. So spring is kind of here. It's kind of here. So thank you very much, guys. Thank you, Joe. I didn't see Tom here today, so Tom may still be traveling. And Laura, you're welcome. And she says, looking forward to part 2 of The Body in the Snow. I think it's been a good production so far. Just from a production standpoint, I think they've done a good job of capturing the drama and creating a little bit of intrigue without unfairly creating it. So can I go live earlier? What do you mean on trial? You mean on hearing days or at night? I mean, so I went live last night at 7:30. So that's about as early as I usually want to go. But I know that's not always convenient for other people, depending what time zone they're in. But I'm sorry, it has to kind of work around my convenience too. So I could maybe occasionally do a special show, but 8 o'clock really works out the best for me. All right, guys. Thank you very much. We'll talk soon.